All right, let's get straight into it. We talk a lot about how contracts start, right? But what about how they end? How does a promise, a legally binding deal, officially come to a close? That's exactly what we're tackling today.
So think about it for a second. When is a deal truly done? When can both parties just walk away completely free and clear of their obligations? It's not always as simple as a handshake and getting the job done. In legal terms, this whole process is called discharge, and it's basically the official end of the line for a contract.
And here's our roadmap for this explainer. There are basically 6 different ways a contract can end according to the Indian Contract Act. We're going to cover all of them, from the easy, happy endings to, well, the not-so-happy ones. So let's start with the good stuff. First up, the amicable endings. Think of these as the happily ever after for contracts, where things go according to plan or everyone just agrees to part ways on good terms. Okay, so the most obvious way a contract ends is by actually doing what you promised. This is called discharge by performance. Now, this can happen in 2 ways. First, you've got actual performance. This is the textbook ending. I do my part, you do your part, boom, we're done. Simple. But what if you try to do your part and the other person says, nope, don't want it? Well, that's called attempted performance. And the law says, hey, you tried. You offered to hold up your end of the bargain. If they refuse, you're pretty much off the hook. But what if circumstances change? What if both of you just decide, you know what, let's not do this?
Well, you can. Under Section 62 of the Contract Act, you can end a contract the same way you started it, with mutual agreement. It's like hitting the undo button together. And there are a few different ways you can go about this.
So 2 key terms you need to know here are novation and alteration. They sound similar, but there's one massive difference. With novation, you're literally swapping out the old contract for a brand new one. You might even swap out one of the people involved. But with alteration, you're keeping the original contract and the original people. You're just, well, altering it. The big takeaway, novation can mean new parties. Alteration is always the same parties, just a different deal. And then you have the simplest of all, recession. This is the let's just forget the whole thing ever happened option. Both of you agree to cancel the contract, tear it up, and walk away. No harm, no foul. It's a clean break before anyone has even had to perform their duties. Okay, now for a really interesting one called remission, which comes from Section 63. Let's set up a scenario. Imagine someone owes you 5,000 rupees. That's the original deal, the amount set in the contract. But what if you say to them, look, just give me 2,000 and we'll call it even. If you accept that lesser amount as a full and final payment, the entire 5,000 rupee debt is legally gone, wiped out, discharged. That's remission. You're basically forgiving part of the debt, and the law honors that. So, those are the nice, clean ways to end a contract. But life isn't always nice and clean, is it? What happens when something totally unexpected happens? This brings us to the endings that are caused by forces way beyond anyone's control. This is where we get into a really cool legal concept called the doctrine of frustration. You might also hear it called impossibility. The idea, from Section 56, is pretty straightforward. If something happens after you've made a deal that makes it physically impossible or illegal to carry out, the contract just becomes void. The key here is that it has to be something nobody saw coming, and it can't be anyone's fault. And to really get our heads around this, there's no better example than the landmark case that basically created this rule. Taylor versus Caldwell. This is the story of a music hall that went up in flames. So here's what happened. Someone signed a contract to rent out a music hall for a few concerts. Super simple. But then, disaster strikes. Before any concerts could happen, the entire hall burned to the ground. Suddenly, the very thing the contract was about, the hall, was gone. You can't hold a concert in a pile of ash, right? Performance was now literally impossible. The court said, look, nobody's to blame here. The contract is just frustrated. It's over. And it's not just about buildings burning down. This doctrine also applies when the subject matter is a person's unique skill. Which brings us to another classic case, the story of the sick pianist in Robinson versus Davison. Here, a very talented pianist was booked for a concert. The whole point of the contract was her specific ability to play. But then she got very sick and couldn't perform. The court made a really important ruling. They said because the contract hinged entirely on her personal health and skill, her illness made it impossible to perform. It wasn't her fault, so the contract was frustrated. It was discharged due to what's called personal incapacity. There are other wild scenarios too. For instance, a sudden change of law. Imagine you have a contract to sell something, and overnight the government bans it. The contract is frustrated because it's now illegal. Or how about a declaration of war? A contract you have with someone who is now considered an alien enemy can become void. These are huge external events that just nullify the deal. And just to round out the unexpected category, there are two more quick ones. First, lapse of time. Basically, contracts have an expiry date for enforcement. If you don't act on a breach within a certain period, you lose your right to sue. The contract just dies on the vine. Second is operation of law. This is when a legal event automatically kills the contract, like if someone goes bankrupt or, in some cases, if a party to the contract passes away. All right, we've had the good endings and the unexpected ones. Now, we get to the messy one, the dramatic one. This is what happens when a contract ends not by agreement or accident, but because someone breaks their promise. And that, of course, is a breach of contract. It's pretty much what it sounds like. One party fails to do what they said they would do without any good legal reason. They might just not show up, they might say I'm not doing it, or they might even do something that makes it impossible for them to fulfill their promise. This is the contentious ending because now someone is at fault. Now, a breach isn't just a breach. There are two main types. You have actual breach. This happens on the day performance is due. The delivery date comes and goes and no rice. That's an actual breach. But then there is anticipatory breach. This is when someone tells you before the due date that they're not going to deliver. The huge difference here is that you don't have to wait for the due date to take action. You can sue them right then and there. So there you have it. The 6 major pathways for how a contract can end. We've gone from friendly handshakes to fiery disasters and broken promises. But so what? Why does any of this actually matter to you? Well, it matters a whole lot. Because knowing these rules is like having a superpower in business and in life. It lets you handle disputes way more effectively because you know when the deal is actually legally over. It means you know your rights if some crazy unforeseen event happens. But most importantly, it makes you smarter from day one. It forces you to think not just about starting a contract, but about all the ways it could potentially end. Which brings us to one last crucial question for you to think about. Every contract you've ever signed had a start date. That's the easy part. But have you ever really planned for its end? Because, as we've seen, planning for the conclusion is every bit as important as negotiating the beginning.